The mismatch between housing costs and the reality of income for low-wage earners and those on a fixed income make it impossible for so many tenants in DC to access affordable housing. Vouchers make that a possibility. And discrimination of voucher holders, which is endemic in DC, makes it impossible for those who have vouchers to access affordable housing units throughout the city. In this case, we had a client who had a voucher. So he had that magic piece of paper that would offer him the opportunity to move anywhere in the city. And he went to an apartment building that was near the resources that he needed to access. And he was approved for the unit on his own merits. At the point he submitted paperwork saying, I have a voucher and I want to use this voucher in this location, the rent all of a sudden went up. Not only did it go up, but it went up beyond what the voucher would allow. In this particular case, staff from Housing Counseling Services worked with our client and contacted the management company and explained the voucher program that he was enrolled in and that he couldn't move in at the higher price that they offered. And they were relentless in insisting that they had the right to charge more for this unit based on the voucher. In this case, the rent was increased solely based on the fact that this person used a voucher rather than their own employment income, for instance. And in that case, it was clearly a violation of the Human Rights Act. A group of us met, spoke with this client, and went through what exactly he experienced. We offered him the opportunity to take legal action. At first, he was really reluctant. He just wanted a place to live. We always explain to clients who experience fair housing violations that it's not just their experience that matters, but that if they want to impact the future of equitable access to housing, they should consider what they do as something to benefit their children and their grandchildren. After that discussion, this client was all aboard, and he said absolutely he'd like to speak to an attorney, and our closest connection has always been with the Washington Lawyers Committee, who have provided assistance to our staff on general matters and in more particular cases like this.
Discrimination against a person who uses a voucher to pay some or all of their rent is not only illegal, but a driver of racial segregation in housing. Together with Crowell & Mooring and the Neighborhood Legal Services Program, we won an important decision that charging a higher rent for a voucher holder than for other tenants is a form of illegal discrimination. The case, brought on behalf of Robert Evans and the Housing Counseling Services, will open up opportunity for other voucher holders across the district. We congratulate Crowell & Mooring and the Neighborhood Legal Services Program. Residents in the district's historically Black and Latinx neighborhoods face underinvestment, displacement, and gentrification. Amongst the most powerful tools for communities to maintain their housing and their neighborhoods is to come together and collectively address concerns with their landlord. But when tenants exercise their right to organize, they are often faced with obstruction and illegal retaliation. In 2021, Cohen, Milstein, Sellers, and Toll and the committee brought the first case to protect the right of tenants to organize. Park 7 tenants have been attempting to organize for years, only to have their efforts disrupted by the landlord and their leaders subjected to retaliation. In a first-of-its-kind consent decree, the tenants' right to exercise their collective power is protected. This Outstanding Achievement Award recognizes Cohen Milstein for this important work.